One thing that people are always asking about DWIs is whether they should take the test after they've been arrested, and this is usually at the police station or at the hospital. And recently there was a United States Supreme Court case that came out called Birchfield versus North Dakota, or here in Minnesota the case was often referred to as Barnard versus Minnesota because that was the Minnesota case that went up with the North Dakota case. The issue in that case was whether or not the government can make you take a blood, urine, or breath test in a DWI case or charge you with a crime if you don't. And here's how the law plays out. In the United States, a blood, breath, or urine test is considered a search under the Constitution. And usually if law enforcement wants to perform a search, they either have to have a search warrant or be able to identify an exception to the search warrant, like your consent or something like that. So the United States Supreme Court recently issued this Barnard decision for Minnesota, and what it said is the following. In Minnesota, if law enforcement asks you to take a breath test, and I'm not talking about the one on the side of the road, I'm talking about after you've been arrested for DWI when you're back at the station. If you refuse to take a test, they can charge you with a crime because it is not unconstitutional for the officers to ask you to take a breath test even if they don't have a search warrant. And they said it's okay to charge you with a crime for refusing to take a warrantless breath test. So now, under 99% of the situations, your best bet is to take the breath test if law enforcement doesn't have a search warrant. And it's a crime if you don't do it. As far as a breath or a blood test goes, though, the Supreme Court said, wait, blood is more private than breath. It's more intrusive when you get someone's blood from them than to get their breath from them, because blood can have things like DNA and other things in it. And therefore, law enforcement usually does need to have a search warrant or an exception to the search warrant in order to get your blood from you. So generally, they cannot charge you with a test refusal if you refuse to take a blood test if they don't have a search warrant. As for urine, they haven't answered that question one way or the other yet. My guess is that the courts are going to say that urine is also more protected than breath, and therefore law enforcement also needs to have a search warrant to ask you for a urine test. But that answer hasn't come out quite yet. It will pretty soon here. So to round it all out, if you're arrested for a DWI and law enforcement asks you to take a breath test, they don't need to have a search warrant under Minnesota law anymore. If they ask you to take a blood test, they generally do need to have a search warrant. And the urine test, we'll see what the answers are. Now, recently, we've gotten some good results in cases where law enforcement tried to take blood or urine and charge someone with a test refusal, and we've argued that they didn't have a search warrant and that people's constitutional rights were violated for alleging that they refused to take a test, which ultimately is unconstitutional anyway without a search warrant. So if you have more questions about DWIs, you can call us. My name is Attorney Ryan Pasiga, and you can find me at arrestedminnesota.com.